It's late. Red and blue lights flash in your rearview mirror. Your heart starts pounding. You pull over. An officer walks up to your window and says calmly, "License and registration." But what if you're not driving? What if you're just walking down the street, sitting in a park, standing outside your own home, and then comes the question that makes everything tense. Do you have ID on you? Most people think the answer is simple. Either you do or you don't. But in the United States, the real answer is far more complicated, and it could mean the difference between walking away freely or ending up in handcuffs. Tonight, we're breaking down exactly when you have to show identification in America and when you don't. And the truth depends on one critical factor most people don't understand. Imagine this, you're driving through Arizona at night, you're obeying traffic laws. Suddenly, you're pulled over for a broken taillight. The officer approaches and asks for your driver's license. In this situation, the law is clear. If you're operating a motor vehicle, you must present a valid driver's license when lawfully stopped. No debate, no gray area. Every state requires drivers to identify themselves during a traffic stop. But that's the easy scenario. Now let's shift the scene. You're walking down a sidewalk in Nevada. Two officers approach you. They say there's been a report of suspicious activity in the area. You match a general description. They ask for your ID. Do you have to show it? Here's where things get interesting. In 1968, the U.S. Supreme Court decided a landmark case called Terry vs. Ohio. That decision created what we now call a Terry stop, also known as a stop and frisk. The court ruled that police can briefly detain someone if they have reasonable suspicion that the person is involved in criminal activity, not a hunch, not a guess. Reasonable suspicion based on specific facts. But the ruling didn't automatically mean you had to produce identification. That question came decades later. In 2004, another Supreme Court case, Hebel versus 6th Judicial District Court of Nevada, answered it. The court ruled that in states with stop and identify laws, a person must identify themselves during a lawful Terry stop. Notice the key word there, lawful. If the stop itself isn't legally justified, the requirement to identify yourself collapses. And here's the twist most Americans don't know. Not every state has a stop and identify law. Some states require you to provide your name if an officer has reasonable suspicion. Others don't. In certain states, refusing to identify yourself during a lawful stop can lead to arrest. In others, silence isn't a crime. So the real answer to, do you have to show ID, is this. It depends on three things. First, are you driving? Second, are you in a stop and identify state? Third, is the stop lawful to begin with? Let's unpack the tension inside that third factor. Reasonable suspicion sounds simple, but it's often where everything becomes contested. Officers must be able to articulate specific facts suggesting criminal activity. Maybe you're pacing outside closed businesses at 3 a.m. Maybe you match a detailed suspect description. Maybe you're seen trying door handles in a parking lot. But wearing a hoodie, standing on a corner, recording police activity, those alone are not crimes. The Fourth Amendment protects you from unreasonable searches and seizures. That means police can't detain you without legal justification. If there's no lawful detention, there's no obligation to identify yourself in most circumstances. And here's something even more surprising. Even in stop and identify states, you usually only have to state your name, not hand over a physical ID card, not answer additional questions, just your name. Of course, real-life encounters rarely feel that simple. Picture this scenario. You're sitting in a public park in Texas. An officer approaches and says there have been complaints about vandalism. He asks what you're doing. You say you're just relaxing. He then asks for your ID. Texas is a stop and identify state, but only if you've been lawfully arrested. During a mere detention, you're generally required to give your name only if lawfully arrested, not just detained. See how nuanced this becomes? Now let's raise the stakes. What happens if you refuse? In a state covered under Hebel v. 6th Judicial District Court of Nevada principles, refusal during a lawful stop could result in arrest. But if the stop lacks reasonable suspicion, your refusal might actually be protected. That's the razor's edge. In the moment, you may not know whether the stop is legally valid. The officer believes it is. You may disagree, and that disagreement plays out on the street, not in a courtroom. This is where many people make emotional decisions that escalate the situation. It's important to understand something critical. The Supreme Court has never ruled that you must carry identification at all times as a general requirement. There is no nationwide law demanding that Americans always carry ID when walking around. But driving? Different story. Operating a vehicle on public roads is considered a licensed activity. The state can require proof you're legally allowed to drive. Walking down the street? That's a constitutional right. Another scenario, you're filming police during a traffic stop, not interfering, just recording from a distance. An officer approaches and demands ID. Courts across the country have repeatedly affirmed the First Amendment right to record police in public. Simply filming is not grounds for detention. Without reasonable suspicion of a separate crime, there may be no legal basis to demand identification. But again, tension lives in the gray areas. If an officer claims you're interfering, even verbally, they may attempt to justify a detention. Whether that holds up later is a different question. Let's pause for a moment. Think about how often people assume they must comply with every request: the uniform, the authority, the flashing lights. It's intimidating. But legally, there's a difference between a request and a command backed by law. If an officer casually asks, "Mind showing me your ID?" that's not automatically a legal order. You can ask calmly, "Am I being detained?" If the answer is no, you're generally free to leave. If the answer is yes, the next question becomes, what is the reasonable suspicion? Now, here's where human psychology enters. Even if you are legally correct, refusing can escalate tension. Officers may perceive refusal as suspicious. Encounters can spiral. That doesn't change your rights, but it changes the emotional reality of the moment. That's why understanding the law before you're in that situation matters. Let's talk about identification versus answering questions. Even in stop and identify states, you're typically not required to answer investigative questions beyond identifying yourself. The Fifth Amendment protects against self-incrimination. Saying your name is usually not considered incriminating, but answering, "Where are you coming from?" or "What are you doing here?" may be voluntary. Many legal experts suggest a calm, measured response. Provide required identification if legally obligated, then clearly state you wish to remain silent and would like an attorney if the situation escalates. Now imagine a protest setting, crowds, emotions, police lines. You're standing peacefully holding a sign. An officer demands ID from everyone in a particular area. Can they do that? Mass ID checks without individualized reasonable suspicion are constitutionally questionable. Courts generally require specific justification tied to particular individuals. But large-scale situations sometimes involve curfews or emergency declarations. In those cases, failure to comply with lawful orders could result in arrest, separate from identification laws. This is why context is everything. Let's return to the central truth. The answer depends on whether the stop itself is lawful. If police lack reasonable suspicion, the detention may violate the Fourth Amendment. If the detention is unlawful, requirements flowing from it, including identification demands, may also be invalid, but that determination is rarely settled in real time. It's settled later, in court, after reports are written, after footage is reviewed. And here's a reality many people don't like hearing. Even if you're right legally, resisting physically or escalating verbally can turn a simple encounter into serious charges. Courts consistently advise resolving disputes later rather than on the street. So what's the smartest move? Stay calm. Ask if you're being detained. If you are driving, provide your license. If you're lawfully detained in a stop and identify state, provide your name. Avoid volunteering extra information. Don't argue constitutional law roadside. Preserve your rights without provoking unnecessary escalation. Because the law isn't just about what's written, it's about how situations unfold. One final twist. Border zones, within 100 miles of U.S. borders, can involve immigration enforcement authority that complicates identification rules. Federal agents may have expanded powers at checkpoints, but even there, rights still apply, and citizenship questions carry specific legal boundaries. The deeper you look, the clearer it becomes. The United States doesn't have one simple rule about ID. It has layers: Supreme Court precedents, state statutes, constitutional protections, real-world discretion. And that complexity is intentional. It reflects a balance between public safety and individual liberty. So next time someone confidently says, "You always have to show ID," you'll know that's not entirely true. And when someone says, "You never have to," you'll know that's not entirely true either. It depends. It depends on where you are. It depends on what you're doing. It depends on whether the stop is lawful. And perhaps most importantly, it depends on how you handle the moment. Because in those flashing red and blue lights, knowledge isn't just power. It's protection. Stay informed, stay calm, and know your rights before you need them.